talk about voir dire, also known as jury selection. First of all, the main objective in jury selection is to discover any obvious or hidden bias that the prospective juror may have for or against your client. A secondary but very important goal of a successful voir dire is to establish a positive relationship with each juror. Basically, get them to like you. People tend to believe the people that they like, trust, and respect. Now, in order to gain a juror's respect, you must be respectful of them. Towards that aim, start out recognizing the hardship and inconvenience of jury duty and thank them for serving. You also gain their respect when you are prepared and listen to their responses. To do this, you must not put on airs. You must be yourself. People, including jurors, can tell if someone is phony. The more prepared you are, the more confident you will be, and confidence resonates with potential jurors. Let's talk about using a jury questionnaire. The best way to convince a court that a questionnaire would be appropriate is to show how it will save time in the long run and address particularly sensitive issues up front without causing juror embarrassment. Of course, you'll rarely be successful in getting a questionnaire approved on the first day of trial. You should cooperate with opposing counsel. Agree on a draft in order to have the best chance to obtain the court's consent. Bias is what we're after, and everyone has bias, including the jurors on your panel. Sometimes the juror recognizes his or her bias, and sometimes they do not. For example, people may have an implicit bias for tall leaders. Do you know that less than 15% of American men are over 6 feet tall? Yet almost 60% of corporate CEOs are over 6 feet tall. This is also true for leaders in the military and even for the presidents of the United States. So biases can come in many forms. Some of the most common involve gender, sexual orientation, racial or ethnic bias. So it's important to flesh out these and other potential biases in voir dire. For example, in the Orange County Register case, I represented low-level employees of foreign descent who worked for the newspaper. Through the jury questionnaire and in-person voir dire, I was able to flush out biases held by jurors against such employees and first-generation immigrants. If I had not flushed that out, I may not have won the case and most certainly would not have had such a successful result. Another example, later in another case, where I represented a person who was a homeless alcoholic but was severely injured by an OCTA bus, I was able to effectively utilize the jury questionnaire and in-person voir dire to flush out people's biases against homeless and or alcohol abuse, which was critical in our winning the case at trial. So you can also use the jury questionnaire and voir dire process to inoculate the jury to point out facts in your case. You also would want to bring up the negative issues first before the defense does the opposite. You want to enlighten the jury about bad issues in the case while trying to put as positive a spin as possible on those bad facts. You also need to point out the bad facts because failing to do so would let your opposition point out the bad facts in a very negative way for you. So you should put your best spin on the bad facts, and you need to do it during jury selection because you have to know the response of the jurors and you have to be able to ask them questions concerning that issue. Now, what is an effective voir dire? Well, of course, questionnaire is good, but in-person voir dire is also crucial. During jury voir dire, the jury is actively watching trial counsel, his or her staff, and everyone in the courtroom. This is the time when jurors eagerly search for an understanding of what is to follow. Selection of a jury panel gives counsel an opportunity to impress the panel with his or her own presence. One way to impress the jury is not to bore the jury from the outset. On too many occasions, attorneys do voir dire examination in a lockstep manner. For example, they'll start with juror number 1, ask 5 questions, do none or little, if any, follow-up, and then proceed to juror number 2, and consecutively down the line with the same 5 questions. By the time counsel gets to juror number 3, the jurors have lost interest. Each one has learned what the questions are and what an acceptable response would be. Nothing of significance concerning a juror's attitudes and beliefs have been elicited. The progress continues through to the last juror when the jury panel can then arise from their combined slumber. This process does not generate positive feelings in the jury towards the examiner, often quite the opposite. There is a better way, however. An effective examination will keep all the jurors on their toes. This can be accomplished by bouncing from one juror to another in no predictable pattern. The jurors realize that they can be called at any moment. For example, going from juror number 8 to juror number 2 to juror number 12 and back to number 8 leaves them with the understanding that they can be called on more than once and at any moment. Also, the questions to a juror may very well ask if they agree with an earlier juror's response to a prior question. Now, the jury knows that their name can be called at any time, and they may be asked questions about another juror's response. The result is an attentive jury. This is in stark contrast to the boredom the lockstep approach produces. In very limited circumstances, some courts do not allow an attorney to refer to the jurors by name, but only by their number. There is no such rule in Orange County for civil cases. In courts which allow counsel to refer to the jurors by their name, it's a good practice to memorize their names. With some practice, this can be easily done when the jurors are first called to join the panel during the court's obligatory instructions to the panel before counsel is allowed to voir dire them. The way that's done is all the jurors' names are announced. You write their names down, you have where they're seated, and then when the judge is asking them questions or telling what the experience is going to be like, you're simply looking at juror number 1, 2, and 3 and memorizes their names. Smith, Jones, Ramirez. Ramirez, Smith, Jones. Back and forth till you have it. And then you do the first 6, the next 6, and often there's 18, the next 6. And you do each row, and then you bounce back and forth, and if you miss one, you look at your notes. So by the time you get up, you've now committed to memory every one of the jurors' names. As with all people, the jury is impressed when the attorney not only bounces from one to another juror with the examination, but does so by referring to each juror by his or her own name. The impression now left with the jury is the counsel is very competent, engaged in the process, and someone they can rely upon to present an effective and interesting case. Additionally, people appreciate and like when someone remembers their name and refers to them by name. This is especially true when a trial attorney is able to do it without notes and on the spot. The questions that attorneys ask during voir dire can also alert the jurors to what is coming, asking potential jurors if they have ever had an opportunity to judge another person's credibility, and whether they believe they can differentiate between a lie and the truth. That makes jurors aware that this case is likely to have conflicting testimony. This becomes the foundation for the theme of honesty versus deceit. Questions to the jurors about whether they had any moral, philosophical, or religious reason that would inhibit or limit their willingness to award large compensatory or punitive damages lets the jury know they'll be making decisions regarding large amount of money and potentially evil conduct. I had a case where I had all the jurors commit to me that if the facts and the law would allow, or if not allow, require the imposition of punitive damages, that they would be willing to vote for punitive damages. During deliberation, one juror said she could not vote for punitive damages. The other jurors got on her and said, wait, you promised Mr. Callahan that if the facts and law supported it, that you would support a punitive damage award. That case resulted in a unanimous $934 million verdict. So again, it's important to get commitments from the jury and also to advise them that high numbers may be coming into play. Later, the jury will be more susceptible to supporting a high award and be watching for evil conduct as it arises. Now, questions should also alert individual jurors to be on the lookout for evidence that may fall within a given theme. It can also be used by counsel to obtain a pledge from the jurors that they will act in accordance with the counsel's wishes if the evidence comes forward as suggested. By example, as I mentioned, you can say to the jury, if the facts and law support one result, would you work during deliberation to convince the other jurors of your position's merit and your factual interpretation? In so doing, the trial counsel creates allies and advocates during deliberations that can turn the tide in counsel's favor. Likewise, if a juror states that he or she will follow the law as instructed, it empowers the jurors to remind that other juror later during deliberations of the pledge made earlier to counsel, as the example I just gave you. The bottom line on jury selection, it should put the jury on the lookout for the evidence that is consistent with your theme. Then, when the evidence does appear, the jury will recognize its significance as it fits neatly into counsel's case theme. In Voir, a defendant will try to focus the jurors' feelings away from any natural sympathetic feelings they may have towards an injured person. Examples of this can be as follows. A theme can be that people naturally have a duty to try and improve their condition, whether to mitigate damages on a business case or seek appropriate treatment in a personal injury case. For example, an attorney may say to a jury, you may hear testimony that there has been no physical therapy or other effort by the plaintiff to mitigate damages since that event. Would you be opposed to the notion that this could have exacerbated her current condition, or that her condition may not be as severe as she suggests? Another use is to make sure the attorney is not considered cruel or callous in his examination of the plaintiff concerning her medical condition. For example, the attorney may ask, we may ask some tough questions about medical injuries the plaintiff is claiming. Will you resent me for asking these questions? Yet another example used by defense attorneys to suggest that the plaintiff is unreasonable in filing this lawsuit. For example, the attorney may ask, have you ever been in an accident and not felt the need to file a lawsuit? Now, in addition to those comments, there are little tips that lawyers talk about how they determine whether a juror is a possible plaintiff juror or defense juror. There are standard stereotypes that may indicate a juror's leaning. For example, nurses, social workers, teachers, outliers, or social misfits may lean towards a sympathy for a plaintiff, while business owners, accountants, and people that are comfortable and established adults with a solid family background may lean for the defense. Now, these are only tips you keep in the back of your mind. It's not something you want to necessarily rely on. You want to rely on the responses they give to your questions, but also, sometimes there's some truth that nurses and social workers do lean towards a plaintiff. Now, there's more you can rely on. There's a common signal that also will give an indication of a juror's unknowing bias. If a jury is asked what they think of our jury system, and they respond, everyone has a right to it, that usually suggests a plaintiff juror. On the other hand, if the juror's response is, it's probably the best system we have, may imply a defense juror. Additionally, this is key. If a juror responds with comments like, I feel versus I think, typically the jurors favoring feelings may more likely be a plaintiff juror. Now, it's not just what they say, it's what they do. You should also watch for non-verbal communication. If a juror exhibits non-verbal communication, such as folded arms, hostile or disinterested personality, then you or your client have not resonated with this person at all, and that juror should be struck. If in asking your questions you get a response from one that implies bias against your client, you should ask, who agrees with the opinion of Mr. Smith? Those that raise the hand may also need to be seriously considered for a strike. On the other hand, if a juror gives you a very favorable response, you may want to ask, does anyone disagree with Mr. Smith's comment? If they do, they are another candidate for a strike. So I believe it's also important in a civil case to discuss the burden of proof and the distinction between a civil and a criminal case. In a civil case, the jury need not be convinced. All that is needed is a belief that is more probable than not, even if they're still having serious doubts. Lastly, challenges. If you have a juror who says negative things, try to have him expand on that belief so later you can prevail on a challenge for cause. You want to draw as much negativity out of that juror as possible so that if the judge does try to rehabilitate the juror, he will not be able to do it, and you'll be able to eliminate that juror on cause and not have to use one of your preemptory challenges. After challenges for cause, each party typically has 6 preemptory challenges and 1 additional challenge for each alternate. Now the plaintiff has a right to the first challenge. Here's something for you, if the plaintiff is reasonably certain that the defense will strike 1 or 2 jurors, the plaintiff can pass, forcing the defense to use one of their challenges first, thus leaving the plaintiff with 6 challenges remaining and the defense only 5. The plaintiff can pass again if there's still a terrible juror that the defense has to get rid of. And then if the defense does challenge that juror, now the plaintiff has 6 challenges left and the defense only 4. Keep in mind though, this is a risky endeavor and should not be approached lightly, since once both parties pass, the jury has been selected. However, if you do this and you are successful, then you can look to the jurors that are coming up next and be able to better select because you have more challenges coming. You may see right after the last juror, there's 2 more coming that you've already questioned, and they have wonderful responses. So since you've saved your challenges, you eliminate a couple you probably would have kept to get to the ones you love.